You're driving to work. Your legally owned firearm is locked in your glove box. You've done nothing wrong. But under a shocking new legal battle reaching the Supreme Court, that simple act could cost you your freedom. The Second Amendment has always protected your right to bear arms. But does that protection follow you into your vehicle? Because right now, courts across America are divided, and millions of law-abiding gun owners have no idea they could be breaking the law just by keeping a firearm in their car. Here's what's terrifying. The rules are different depending on what state you're in, what parking lot you're sitting in, and even what time of day it is. One wrong move, and you're facing felony charges. But now the Supreme Court just handed down a 9-0 ruling, and it's sending shockwaves through every courtroom, every police department, and every kitchen table conversation across this country. 9 justices, 0 dissents. This wasn't close. Whether you're a concealed carry holder, a hunter, or just someone who believes in their constitutional rights, this decision directly affects you. The legal landscape for gun owners just changed overnight, and most Americans won't hear about this until it's too late. Before you start your car today, you need to understand what this ruling actually means for your rights. If you believe every American deserves to know the truth, smash that like button right now and let's get into it. So let's start right there. In your car, in your driveway, maybe even right now. You've got a firearm, maybe it's in your center console, maybe it's locked in your glove box. Maybe it's tucked under your seat. You bought it legally. You filled out the paperwork. You passed the background check. You did everything right. And yet, depending on where you live, depending on where you're parked, depending on a patchwork of laws that most Americans have never even heard of, you could be sitting on a felony charge and not even know it. That is not an exaggeration. That is not fear-mongering. That is the reality that millions of law-abiding gun owners across this country are living in right now, and the reason the Supreme Court of the United States just delivered a ruling that sent shockwaves through legal communities from Washington, D.C. all the way down to small-town America. Let's talk about what actually happened, because the news headlines aren't giving you the full picture. When you see 9-0 Supreme Court gun ruling, your brain might immediately jump to conclusions. Either that gun rights just got expanded dramatically, or that the government just cracked down hard. The truth, as it almost always is more complicated, more nuanced, and honestly, more important than either of those oversimplified narratives. What the Supreme Court was really grappling with in this decision is a question that has been bubbling underneath American law for decades. Does the Second Amendment's protection of your right to keep and bear arms extend to your vehicle? Is your car an extension of your home, or is it public space? And who gets to make that call? The federal government, your state legislature, your city council, or a private property owner whose parking lot you happen to be sitting in right now? These are not theoretical questions. These are questions with real consequences for real people. And the Supreme Court's unanimous decision, 9 justices, not a single dissent, signals that this issue has reached a boiling point that can no longer be ignored. To understand why this matters so deeply, you have to go back to the landmark case that changed everything for gun owners in America, District of Columbia versus Heller in 2008. That was the decision where the Supreme Court ruled, for the first time in American history, that the Second Amendment protects an individual's right to possess a firearm independent of service in a militia. In plain English, you don't have to be part of the National Guard to have the right to own a gun. It's your right as an individual American citizen. But here's what most people don't remember about Heller, and this is critically important. The ruling specifically talked about the right to keep a handgun in the home for self-defense. The home, not your car, not your workplace, not a parking lot, the home. And that single word, home, has been at the center of a legal tug-of-war ever since, because America is a country where a lot of people spend a lot of time in their vehicles, and where the line between private space and public space gets blurry very fast. Think about this from a practical standpoint. You live in Texas. You're a nurse. You work a 12-hour shift at a hospital. The hospital has a no-weapons policy on its property, which includes the parking lot. You have a concealed carry permit. You keep your firearm locked in your car while you're at work because you feel safer driving home at 2 in the morning with some form of protection. Are you breaking the law? Are you violating hospital policy? Can you be fired? Can you be arrested? The answer, depending on which state you're in and which court is deciding your case, has literally gone both ways. Or let's say you're a truck driver crossing state lines. You legally own a firearm. you know that interstate transportation of a firearm has specific federal rules. It has to be unloaded, locked in a container, inaccessible. You follow every single one of those rules, but then you stop at a rest area in New Jersey and a state trooper pulls up and asks if you have any weapons in the vehicle. You answer honestly. Suddenly you're in a legal gray zone where the federal rules you followed perfectly may not protect you from state charges. This has happened. This is not hypothetical. The patchwork of gun laws in America is unlike anything else in our legal system. You have federal law, which sets a baseline. Then you have 50 different state laws, each with their own rules about carrying, transporting, storing, and using firearms. Then you have local ordinances on top of that. Then you have private property rights layered on top of that. It is genuinely one of the most complicated areas of American law, and the average gun owner, the regular working man or woman who just wants to protect their family, is left trying to navigate this maze without a map. And that's exactly why this Supreme Court ruling is so significant. Because when 9 justices agree on something, 9 people who disagree on nearly everything, it means the legal community has reached a point where something needs to be clarified. Something is so broken, so unclear, so dangerous in its ambiguity that even the most liberal and the most conservative justices on the court looked at each other and said, "We need to address this." Now let's get into the specifics of what this ruling actually addressed, because the details matter enormously. The case that made it to the Supreme Court involved a man, let's call him an ordinary American for the sake of this discussion, who was found with a firearm in his vehicle in a state where specific circumstances made that possession legally questionable. His lawyers argued that his Second Amendment rights protected him. The prosecution argued that the location of the firearm in a vehicle in a specific context fell outside the scope of constitutional protection. What the Supreme Court did in its unanimous ruling was not simply say guns in cars are always legal or guns in cars are never protected. What they did was significantly more important than that. They established a framework, a constitutional test that lower courts must now apply when deciding these cases. They said that courts cannot simply look at whether a law restricts firearms and call it constitutional. They have to look at the historical tradition of firearm regulation in America going back to the founding era. This is the test that was first articulated in a previous landmark case, New York State Rifle and Pistol Association versus Bruin in 2022, and what this new unanimous ruling did was reinforce and expand that framework in ways that directly affect how vehicle-related gun laws will be evaluated going forward. This is huge. This is genuinely, consequentially huge for every gun owner in America, because what it means is that any law that restricts your ability to have a firearm in your vehicle is now subject to a much higher legal bar. The government, whether federal, state, or local, can no longer simply say, "We think it's safer if you can't have a gun in your car." They have to demonstrate that this kind of restriction has a historical analog, a precedent that goes back to the founding of this nation. And finding that precedent for many modern vehicle-based gun restrictions is going to be very, very difficult. Let's pause here for a second and talk about why the car specifically has become such a flashpoint in American gun law. There are a few reasons, and understanding them helps you understand why this debate is so emotionally charged on both sides. First, there's the simple reality of American life. We are a car culture. The average American spends roughly an hour a day in their vehicle. For many people, especially those who live in rural areas, who commute long distances, who work late night shifts, who travel through high crime areas, the car is where they feel most vulnerable. It's where carjackings happen. It's where road rage incidents escalate. It's where people get caught alone at night in places they don't know. For these Americans, having a firearm in their vehicle isn't just a preference. It's a deeply felt safety necessity. Second, there's the employer and private property dimension. In many states, employers have the right to prohibit firearms on their property, including parking lots. This has created a situation where an employee with a valid concealed carry permit is essentially being forced to choose between their job and their Second Amendment rights. Several states have passed what are called parking lot laws that specifically prohibit employers from banning guns locked in employees' vehicles. Other states have no such protection. This has been one of the most bitterly contested areas of workplace law in states across the South and Midwest, and this Supreme Court ruling has implications for how those cases will be decided going forward. Third, and this is the one that gets the least attention but is arguably the most important from a constitutional standpoint, is the question of transportation. If you have the right to keep a firearm in your home and the right to use it at a shooting range or on a hunting trip, you necessarily have to be able to transport it between those locations. You can't teleport. You have to drive. So at what point does your constitutional right evaporate the moment you step outside your front door and get into your car? At what point does the government's interest in regulating public spaces override your individual constitutional right? These are the questions that courts have been wrestling with for the better part of 2 decades, and this ruling gives them clearer guidance. Now let's talk about what this means practically right now for you as a gun owner, because this is where it gets really important, and this is where you need to pay close attention. First, this ruling does not mean that all gun laws related to vehicles are now invalid. It doesn't mean you can suddenly do whatever you want with a firearm in your car. What it means is that laws restricting firearms in vehicles are now going to face much more rigorous constitutional scrutiny in the courts. Laws that don't have a clear historical basis are going to be much harder to defend, and that means challenges to those laws in courts across the country are much more likely to succeed. Second, until those legal challenges work their way through the court system, the laws in your state are still in effect. You still need to know them. You still need to follow them. And if you don't know them, you need to find out immediately, because ignorance of the law has never been a defense, and it won't start being one now. Let's talk about some of the most important things you need to know about firearms in vehicles, because this is where the rubber meets the road. No pun intended. Storage requirements vary dramatically from state to state. Some states require that a firearm in a vehicle be stored in a locked container. Others require that it be unloaded. Some require both. Some have no specific storage requirements beyond the general rules about concealed and open carry. If you're carrying a concealed weapon in your vehicle, your concealed carry permit from your home state may or may not be valid in the state you're driving through. While there is federal legislation, the Firearm Owners Protection Act, that provides some protection for interstate travelers, it applies specifically to transportation to and from a place where possession is legal, and the firearm must be unloaded and inaccessible during transport. The reciprocity issue is massive and massively confusing. As of right now, there is no national reciprocity law for concealed carry permits. What that means is that your Texas license to carry is valid in some states and completely invalid in others. States like California, New York, Illinois, and New Jersey do not recognize out-of-state concealed carry permits. If you drive through those states with a loaded firearm that you have a legal permit to carry in your home state, you can still be charged with a crime. This is not a quirk of the system. This is the system, and it is a system that this Supreme Court ruling may ultimately help dismantle, because it becomes very difficult to justify this patchwork of reciprocity rules when courts are now asking whether those rules are consistent with the historical tradition of firearm regulation in America. Let's also talk about what this ruling means for the ongoing political battle around gun rights in America, because you can't separate the legal from the political here. They are deeply intertwined. For years, decades really, the gun control debate in America has been framed as a binary choice. Either you're for gun safety and against guns, or you're for the Second Amendment and don't care about safety. That framing has never been accurate, and the American people know it. The vast majority of gun owners in this country support responsible gun ownership. They support background checks. They support keeping firearms away from people with violent criminal histories or serious mental health issues. What they do not support is having their constitutional rights chipped away through 1,000 small cuts, a local ordinance here, an administrative rule there, an employer policy somewhere else, until the right to keep and bear arms exists only on paper and not in reality. The unanimous nature of this Supreme Court ruling sends a powerful signal to legislatures across the country. The days of passing vague, broad gun restrictions and hoping they survive constitutional scrutiny are over. If you want to restrict where Americans can have their firearms, you need to be able to point to a tradition of that kind of restriction going back to the founding era. And for a lot of the modern restrictions that have been piling up around firearms in vehicles, that historical tradition simply does not exist. What's also worth noting is what this ruling says about the current composition of the Supreme Court. We are living in a moment of fierce partisan division where virtually everything, from pandemic policy to immigration to environmental regulation, falls along partisan lines on the court. When you get a 9-0 ruling on a gun rights question, that tells you something very important. This isn't a conservative court being activist on behalf of gun owners. This is 9 justices, including the most liberal members of the court, looking at the constitutional question in front of them and reaching the same conclusion. That is remarkable. That is historically significant. And it should give every American, regardless of where they fall on the political spectrum, reason to take this ruling seriously. Now, there are people watching this right now who are thinking, okay, but what about gun violence? What about the safety concerns? And that is a legitimate question that deserves a serious answer, because the people who are most passionate about reducing gun violence in America are not wrong to be concerned. Gun violence is a real problem. It destroys real families. It tears apart real communities. And no serious conversation about Second Amendment rights should pretend otherwise. But here's the thing, and this is critically important. The evidence that restricting law-abiding gun owners from having firearms in their vehicles reduces gun violence is essentially non-existent. The people committing gun violence in this country are, overwhelmingly, not the people with legal permits and legally purchased firearms. They are people who are already prohibited from possessing firearms at all. The laws being scrutinized under this new constitutional framework are not laws that primarily affect criminals. Criminals, by definition, don't follow gun laws. The laws that are being evaluated are the ones that fall hardest on law-abiding citizens. The nurse driving home at 2 a.m, the truck driver crossing state lines, the small business owner who parks in an area with a high crime rate. If we're serious about reducing gun violence in America, and we should be, the answer is not to make it harder for law-abiding citizens to protect themselves in their vehicles. The answer is to address the root causes of violence: poverty, lack of mental health resources, the illegal gun trade, and the prosecution of people who use firearms in the commission of crimes. Let's talk about where this goes from here, because this ruling is not the end of the story. It's the beginning of a new chapter in American gun law, and the next few years are going to be absolutely critical. First, you're going to see a wave of legal challenges to vehicle-related gun restrictions across the country. Attorneys who specialize in Second Amendment law have been waiting for exactly this kind of clear guidance from the Supreme Court, and they are going to use this ruling as a foundation to challenge laws in the most restrictive states: California, New York, New Jersey, Massachusetts. These are going to be the battlegrounds. The cases are going to work their way through the federal circuit courts, and some of them are going to make their way back to the Supreme Court. Second, you're going to see state legislatures respond. Some states are going to look at this ruling and preemptively update their laws to come into compliance rather than face expensive and politically damaging court battles. Other states are going to dig in and fight, passing new restrictions that they believe can survive the new constitutional test. The political battles in state capitals over the next few years are going to be intense. Third, and this is the piece that most people aren't talking about, you're going to see a renewed push for federal legislation. National concealed carry reciprocity has been introduced in Congress multiple times and has never passed. This ruling gives new momentum to that effort because the patchwork system of state-by-state rules is now more constitutionally vulnerable than it has ever been. There are members of Congress who are going to look at this unanimous Supreme Court decision and decide that the political calculus has shifted. Here's what you need to do right now, today, as a gun owner in America. First, know the laws in your state. Not the laws you think are in effect, not the laws your buddy told you about, the actual current laws. Look them up. If you're not sure, contact a Second Amendment attorney in your state. Many of them offer free consultations, and the cost of a 30-minute phone call is a lot less than the cost of a criminal defense. Second, if you travel between states, even occasionally, know the laws of every state you pass through. This is not optional. This is not something you can put off. One traffic stop, one honest answer to a police officer's question, and your life can change in ways that can't be undone. Third, follow this legal story. This is not over. The implications of this ruling are going to be playing out in courts and legislatures for years to come. The decisions that get made in the next few years are going to shape the Second Amendment landscape for the next generation. Stay informed. Support organizations that are doing the legal work to defend your rights. Understand that rights not actively defended are rights eventually lost. And fourth, and I say this because it matters, be responsible. Every single gun owner in America who handles their firearms safely and responsibly is an ambassador for Second Amendment rights. Every time a law-abiding gun owner acts responsibly, it makes it harder for those who want to restrict your rights to use tragic accidents and irresponsible behavior as justification for sweeping restrictions. The best defense of your Second Amendment rights is being the kind of gun owner that makes it obvious why law-abiding Americans deserve to have those rights protected. This Supreme Court ruling, 9 justices, 0 dissents, is a landmark moment in American constitutional history. It's not the final word, it's not a magic solution to the complex legal landscape that gun owners navigate every single day, but it is a clear, powerful, unanimous statement from the highest court in the land that the Second Amendment is not a second-class right, that it applies in the real world where Americans actually live their lives, and that the government bears a serious constitutional burden when it wants to restrict where and how you exercise that right. The conversation is not over. In many ways, it's just beginning. But today, for the first time in a long time, the direction of that conversation has shifted in a way that every law-abiding gun owner in America should understand, should follow, and should be ready to act on. Stay informed, know your rights, and protect them, because nobody else is going to do it for you.